Good morning, and welcome to today's Kelso Report for Thursday, May 24th. I'm your host, Clark Kelso. We have cases today involving the law of evidence, choice of law, jury deliberations, professional licensing, and stipulated reversals. We begin with the Ninth Circuit in a criminal case involving an evidentiary ruling. The operation of the hearsay rule in the context of party admissions made through an interpreter was before the Ninth Circuit in United States v. Romo-Chavez. Now, as you know, when an out-of-court statement is offered to prove the truth of the matter asserted, it is hearsay and generally inadmissible. However, a party may introduce the out-of-court statements of his opponent as a party admission, and the courts are willing to treat statements made through an interpreter as statements by the party, so long as there are certain indicia of reliable interpretation. In particular, federal courts consider four factors in a case-by-case analysis of whether an interpreter's statements should be considered the statements of the party opponent. The factors are: 1. Which party supplied the interpreter? 2. Whether the interpreter had any motive to mislead. 3. The interpreter's qualifications and language skill. And 4. Whether actions taken subsequent to the conversation were consistent with the statements as translated. In Romo-Chavez, the interpreter was a Customs and Border Protection officer who had only a basic working knowledge of Spanish. Nevertheless, applying the four factors, a majority of the Ninth Circuit panel held that the trial court did not abuse its discretion in deciding that the interpretation was sufficiently reliable to trigger the party opponent exception to the hearsay rule. In short, you don't have to be a court-qualified interpreter to get the benefit of that exception. Next, California Court of Appeal, a choice of law case. In Lido versus International Rectifier Corporation, the Second District faced the question of whether the termination of a corporate officer for reasons that allegedly violate public policy is a matter within the internal affairs of a foreign corporation and therefore subject to the law of the state of incorporation. The internal affairs doctrine is a conflict of laws principle which recognizes that only one state should have the authority to regulate a corporation's internal affairs. That is, matters peculiar to the relationships among or between the corporation and its officers, directors, and shareholders. Because otherwise, a corporation can be faced with conflicting demands from different jurisdictions. States normally look to the state of a business's incorporation for the law that provides the relevant corporate governance general standard of care. And in Lido, the California-based corporation was incorporated in Delaware. However, the local law of the state of incorporation will not be applied where, with respect to some particular issue, another state has a more significant relationship to the parties in the transaction. Now, factually in Lido, a corporation CEO was removed by the board, and the CEO then alleged the removal was in retaliation for steps the CEO was taking to expose unlawful accounting practices in an overseas subsidiary. According to the Second District, a removal of this sort in violation of public policy triggers vital interests of the state of California, making the internal affairs doctrine inapplicable. Now, here's a creative piece of lawyering in our next case, ultimately unsuccessful lawyering, but still pretty creative. In People v. Singh, a jury convicted the defendant of inflicting a corporal injury resulting in a traumatic condition upon a cohabitant in violation of Section 273.5a of the Penal Code, domestic abuse and violence. The jury also found true the allegations that the defendant personally inflicted great bodily injury, used a deadly weapon, a knife, in the commission of the offense. The trial court sentenced the defendant to 6 years in state prison. Now, on appeal, the defendant contends the trial court erred by first allowing the jury to conduct an experiment during deliberations, and second, allowing the jury to reenact the stabbing of the victim without allowing the defendant to be personally present during that stage of the proceedings. The third district held the defendant did not preserve the first objection by failing to object at trial. As for the second creative argument, it is of course true that under the Sixth Amendment, criminal defendants have the right to be personally present during critical stages of the proceedings. And everybody would agree jury deliberations are critical proceedings. Well, the Sixth Amendment does not apply. It's intended to protect the defendant's right of cross-examination. And that is, of course, an irrelevancy during jury deliberations. Moreover, jury deliberations are historically protected from disclosure. Prior cases have held that rereading of testimony to the jury does not constitute a stage of the proceeding for which a criminal defendant has a constitutional right to be present. And the defendant has no right to be present during the jury's viewing of a crime scene. So, in harmony with these cases, the third district now holds that a criminal defendant does not have a Sixth Amendment right to be personally present during jury deliberations, even when the deliberations include reenactment of the circumstances described by testimony at trial. Nice try on that appellate argument. Next, a professional licensing case, this time involving a dentist. The Dental Board of California revoked a doctor's license to practice dentistry after a mishandled root canal procedure and repeated failure to respond to the patient's complaints of post-procedure complications. In addition to botching the root canal by overfilling the affected tooth, which, within a few hours, resulted in severe pain, swelling, and numbness, and put the patient at risk of permanent nerve damage within a few days, the doctor knew of the error when it occurred, but failed to document it in the patient's dental records. When the patient started calling back with complaints, the doctor did not return any of the phone calls for a full week. He was charged by the board with negligence in failing to maintain complete patient records, negligence in failing to develop and present to the plaintiff a comprehensive treatment plan, negligence in continuing to operate on a patient while the patient was under stress or duress, negligence in using excessive force during the root canal treatment, gross negligence and incompetence in overfilling the patient's tooth, negligence in failing to note, remove, or advise the patient of the overfill, and gross negligence and unprofessional conduct in failing to respond for 7 days to post-procedure phone calls seeking help. The board revoked his license, and the doctor filed a petition for a writ of administrative mandamus, claiming that the sanction was too severe. Although the Superior Court agreed with the doctor, put him back in the office, the First District reversed in Gillis v. Dental Board of California, concluding that the record showed no prejudicial errors and amply supported the board's decision to revoke the license. So the public is safe from this type of incompetent dentistry. Finally, we have a case involving stipulated reversals. Some 20 cities found themselves in a dispute with the State Board of Equalization regarding allocation of sales taxes for sales fulfilled from warehouse locations. The particular details of how the board applied its so-called warehouse rule are not important for understanding this case. What is important is that the Superior Court found against the board, concluding that the board's quasi-judicial decision-making required the board to explain its allocation, which it did not do, that the board improperly applied a rule change retroactively, that it appeared unconcerned with due process, and that it violated the Administrative Procedure Act. Well, in the face of this broad and embarrassing criticism of the board's decision, all of the parties and the board somehow managed to agree upon a settlement reallocating the sales taxes. And the parties then asked the Second District to vacate the Superior Court's judgment as part of a stipulated settlement and reversal. The Second District rejected the request, concluding under Code of Civil Procedure Section 128 that the interests of the public would be affected by the reversal and vacatur of the Superior Court's opinion. In particular, the court held that to vacate the judgment and reinstate the agency's decision would not only imply the agency acted properly, which it did not, it would also undermine the effectiveness of the judgment in exposing the agency's deficiencies in handling the administrative appeal. The court concluded that, quote, the judgment should remain intact as a reminder to the agency that it must comply with the laws that restrict its decision-making authority, close quote. And that's it for today's Kelso Report. Have a great day in the law.